Do we have any opening comments?
Yes, sir. Thank you. Good morning. The Special Magistrate will hear all cases on the agenda. The meeting is recorded and televised on the Wellington Government Access Channel 18 on Comcast Cable. Testimony from Wellington staff and the respondent will be under oath. Although formal rules of evidence do not apply, fundamental due process shall be observed. Special Magistrate may ask questions of each party to determine pertinent facts. The Code Compliance Officer will present his or her case to the Special Magistrate. Services all required notices associated with a case and all photographs presented by the Code Compliance Officer will be entered as evidence unless otherwise disputed. Upon completion of the presentation, the respondent will have an opportunity to comment or cross-examine. Special Magistrate will issue findings of fact based on the testimony presented. If the Special Magistrate determines there are one or more violations of Wellington's codes or ordinances, he or she may issue an order requiring the respondent to correct those violations by a specific date. The Special Magistrate may also assess costs that have been incurred in the prosecution of a case. In most cases, costs assessed by the Special Magistrate are due and payable to Wellington within 30 days from the date of this hearing. Failure to remit payment as ordered may result in a lien being filed against the property. In the event the violation is not corrected by the date specified, the order will also provide a date for a fine certification hearing. No additional notice will be provided to the respondents. A lien will be filed against the property if the assessed fines are certified by the Special Magistrate. The Special Magistrate may also issue a cease and desist order. If issued, the respondent is placed on notice that if the same violation reoccurs within 5 years, staff may notify the respondent of a hearing for a repeat violation. At the hearing, staff will request the Special Magistrate assess a fine. The primary object of a hearing is not to unduly penalize anyone, but to obtain compliance with Wellington's codes and ordinances in a timely manner. Cases where the respondents are present will be heard first. When the respondent comes to the podium, please sign in, state your name, and indicate if you have been sworn in. Please ensure all cell phones are turned off or in silent mode at this time. The Special Magistrate will now swear in all persons who will testify.
Okay, thank you. If you're going to testify, please stand and raise your right hand. You swear or affirm the testimony you're about to give this morning is the truth and nothing but the truth? Okay. Do we have any additions or deletions to the agenda this morning?
No, sir.
Okay. Next item is consent. Unless there's any objection, consent is approved. What's the first order of business this morning?
The first case where we have responded is item number 1 on fine certification on page 4. On page 4. It is NOH 18-1557. John Jarvis is the code officer.
Ready? Okay. John Jarvis, Code Officer with Wellington, case number NOH 18-1557. Respondent's name is Sharon Tawari. Property address is 1256 White Pine Drive, Wellington, Florida. Hearing date was January 17, 2019. The respondent was ordered to correct the violation of Code Section 3622B1 on or before February 21, 2019, or pay a fine not to exceed $50 per day. The order also scheduled a fine certification hearing on March 21st, 2019 if the Code Compliance Division was not contacted as required and or the violation was not corrected. Sorry about that. I thought I turned that off. Jesus. An inspection on February 25th found the roof remained in a state of deterioration in violation of Wellington Code Section 3622B1. However, a permit for a re-roof had been issued by the Wellington Building Department. Photos were taken that represent the condition of the property at the time of the various inspections. Follow-up inspection on March 18th found the violation still exists, and a PACER search found the respondent does not have pending bankruptcy action. Research found there is not a lis pendens filed against this property. I've had several conversations with the owner's representative, John Griffin, and the re-roof was scheduled to have already begun. However, due to weather issues, the start of the work has been delayed. The Code Compliance Division recommends the respondent be found in violation of the order of Wellington Code Section 3622B1. And we are requesting an order to be put in place allowing the respondent additional time to replace the roof. Should the new roof not be completed by a date specified by the special magistrate, then it is recommended that a $50 a day fine be implemented commencing on February 22nd until the violation is corrected. The initial cost of $229.58 assessed in the order have been paid. Additional costs currently stand at $179.33.
When was the permit issued?
It was issued on the day that I did the inspection, which was,
You said March 18th was the
Correct.
last time you were out there?
Yeah.
Why wasn't this a stipulation if you're agreeing to give him additional time?
well, we'd already been through the order, so he had until that time. And the violation is actually for a deteriorated roof, not a permit. So the violation still exists.
All right. Sir, you want to state your full name for the record and sign in?
My name is Johnny Griffin.
Hey, Mr. Griffin, what is your relationship to the respondent, the owner?
I'm a pastor.
Okay. Okay, you heard what code enforcement officer had to say?
Yes.
Okay.
At the time, Miss Sharon is a mother, not a mother, but she's a single person. She don't have the income to really replace the roof. So we at the church is trying to help her out. And so we have the contractor that's in our church also that's doing the roof for her. She got the money out for the materials, so the permit got pulled, so the permit is active. It was going to be done either Friday of last week or Monday of this week, but due to the rain, it got delayed. The material has been paid for, just waiting for the weather to open up so they could tear the roof off and put on the new roof.
How long will it take to re-roof? Or,
If I can get some clear days, about 3 days.
well, what kind of roofing material you put on? Tile? or
Shingles.
Shingles?
Yes, sir.
They put that right on or they have to wait? Do you know?
We have to tear off the old roof.
Yeah, no, when you put the shingles on, usually I know the tiles they put on the roof to make sure the roof is stable. Does anybody know? Can you put shingles right on, or do you have to
Well,
wait?
Usually there's an inspection by the building
Inspection.
department.
Well, I understand the inspection period.
But I mean, before the actual shingles go on, I think they go out and do an inspection before the shingles go on, and then they do a final.
So we're looking about probably 4 or 5 weeks, you think, to do the whole project?
It'll be way completed by then, sir.
Okay. So you're asking me to stay?
Yes, sir.
Well, we just give him an extension.
Well, that's, okay. What are the hearing dates, the next hearing date? And the one after that? May 16th, April 18th, May 16th. Okay. This is March, 21st? So, okay, I'm gonna give you an extension until May 16th.
It'll be
Okay,
done,
I'm
sir.
gonna give the respondent to that, okay?
Fine.
So, and then you bring it back if it's, I'm gonna assess, though, cost of $179.33,
Okay.
okay?
Alright.
Hopefully, the $50 a day is stayed until May, okay?
Thank you, sir.
Okay, thank you for coming.
Thank you.
It's May 16th, okay? You need anything else? Excuse me? Well, it's the same $50 per day.
Right, but the fence are hearing, I guess I should say.
Oh, you want the
Place on the June 20th.
the June 20th. So you have until, what day do we say? May 16th. Okay, if it's not, there'll be a hearing in June 20th.
Yeah.
Get all these dates right, we're already into summer, okay?
One more
Thank you.
Thank you.
One question, please. You
Yes,
say,
sir.
so she paid the two already, she owed what? now?
$229.58 she owed. They said there's an additional cost of $179.33.
What's that cost for?
The processing of the case after the,
How much?
179.33. And that needs to be paid by May 16th. And as soon as the roof is re-roofed, please let Mr. Jarvis know,
I will, sir.
okay?
Thank you.
thank
If
you.
the, do I have to, after we get the pictures and everything to you, you go do your inspection, do I have to come back?
He'll let you know, or the respondent know. All right, thank you. Next case.
Next case will be still under fine certification, item number 5 on page 5. It's NOH 19-129. Deborah Mitchell is the code officer.
Deborah Mitchell, Code Compliance Officer of the Village of Wellington. Case number NOH 19-129. Respondent's name is Palm Beach Polo, Inc. Property address is 11630 Polo Club Road, Wellington, Florida. Hearing date was January 17th, 2019. The respondent was ordered to correct the violation of Wellington Land Development Regulation Section 7.3.12.b on or before February 21st, 2019, or pay a fine not to exceed $250 per day. The order also scheduled a fine certification hearing on March 21st, 2019, if the Code Compliance Division was not contacted as required and/or the violations were not corrected. An inspection on February 26, 2019, found landscaping is not being maintained in a healthy, neat, and orderly appearance, including overgrown grass, weeds, dead and bare areas, and dead fronds, in violation of Wellington Land Development Regulations Section 7.3.12.b, which is in violation of the order. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on March 12th, 18th, and 20th, 2019 found the violations still exist. Excuse me. A PACER search found the respondent does not have pending bankruptcy action. Research found there is not a list pendants filed against the property. Staff has had communication with Mr. Dom, attorney for Palm Beach Polo, Inc., via email. Mr. Dom indicated in an email a plan would be submitted to allow portions of the grass to be maintained as a safety measure against golf balls heading toward the sidewalk, the cart path, and Polo Club Road. No plan has been submitted. The Code Compliance Division recommends the respondent be found in violation of the order dated January 17, 2019, and Wellington Land Development Regulations Section 7.3.12.b, and requests that the special magistrate impose a fine pursuant to Section 162.09 of the Florida statutes.
Are any of these landscape that's not maintained up against any residential area?
Yes.
All right.
Should I continue?
If you have anything, are you done?
No, I'm not
Oh,
done.
I'm sorry.
In determining the amount of the fine, there are 3 statutory factors to consider: the gravity of the violation, any actions taken by the respondent to correct the violation, and any previous violations committed by the violator. The gravity of the violation is evidenced by the property owner's failure to maintain the course's landscaping in a healthy, neat, and orderly appearance. As to the second factor, the respondent has made no efforts to correct the violation. As previously mentioned, Mr. Dom indicated via email on February 8, 2019, that the property owner would submit a plan to permit the grass to remain longer in some areas, but to date, no plan has been submitted, and the violation has not been corrected. As to the final factor, special magistrates have previously interpreted previous violations to mean violations of the same code provision committed by the violator on the same property. This matter is not a repeat violation for this property. However, it is worth noting that the property owner has been previously cited and appeared before Wellington magistrates for violations on various other properties in the village. In light of this evidence as to each of the factors, Wellington requests the respondent be assessed a fine in the amount of $250 per day, commencing on February 22nd, 2019, and costs in the amount of $485.33, which includes costs assessed in the order, both continuing to accrue until the violations are corrected.
Okay, which golf course is this?
This is over by the Dunes course. It's by the clubhouse.
Okay. Is that it?
That's it, sir.
Okay. Good morning, Mr. Dom.
Good morning, Mr. Zhang.
Nice to see you bright and early.
You as well. See you later.
Hopefully.
Okay. First of all, we object to the hearing being held today based on a due process argument. If I could submit Exhibits 1A and B. last evening, I went on to the Village of Wellington website specifically to determine what was to be on today's agenda in order to properly obtain notice of what we would be arguing this morning. And this is the, I guess, the landing page for the calendar for the special magistrate hearing for 3/21. Agenda package, not available. So I went to the published agenda, I clicked the button, that's 1B. And if you take a look at the agenda that was on the village website last evening to provide me with information relative to what was going to happen today, you'll see what I found. There's nothing there. So based on the statute, based on the code, based on the concept that with respect to these magistrate hearings, we're supposed to be dealing with fundamental due process. This provides me with absolutely zero notice of what was going to happen today. I did not know what was going to happen today until I walked into this room and asked for an agenda. So based upon that, this hearing is violating my client's due process rights insofar as we had no notice of exactly what was going to be heard today. Now, they'll argue, oh, gee, you knew that this might be on the agenda. Lots of stuff might be on the agenda. However, we never know from 1 month to the next what's going to be on the agenda, what's not, whether there's a continuance, whether it's on consent, whether it's not on consent. And the only way that we can be prepared to come in here and duly argue these things before this whatever this is, I need to have notice, and this notice is all that was available from the Village of Wellington online from their website, and it's inadequate. So first of all, we object to this hearing taking place today based upon that. I'll go forward, or I'll give them an opportunity to argue that first.
May I respond, Mr. Zangen?
Yes, ma'am.
With respect to Mr.
Can you
Dom,
identify yourself? for the
yes, I'm
record?
sorry. Rachel Bosch, Assistant Village Attorney for the Village of Wellington. With respect to Mr. Dom's due process argument, I would like to point the special magistrate to the order finding violations, which indicates that if the violation is not corrected by February 21st, 2019, that a fine certification hearing will take place today, March 21st, 2019 at 9:00 a.m. So that was the first notice that was provided to the respondent. Additionally, and I only have one copy of this email, but I'd be happy to provide it to you and show a copy to Mr. Dom as well after I tell you what it says, since I don't know off the top of my head. On March 14th, 2019, Mr. Dom sent an email to Mr. Koch asking if there was anything that was presently scheduled to be heard today, March 21st. And Mr. Koch responded with a detailed email that talked about violations on various courses and the status of those violations. And with respect to the Palm Beach Polo driving range, he indicated that the fine certification hearing is scheduled for March 21st, 2019. I'm going to show a copy of this to Mr. Dom, although I believe he's seen it before.
Can we make a copy of this? Get somebody to make a copy so we can make it into evidence? Unless she's going to offer it.
Shane will take care of it.
Are you offering that into evidence?
Yes, I'd like to offer that into evidence. I can give you this copy.
Oh, you don't, okay, we don't need a copy. She's going to.
Well, in response, clearly, the email that I received from Mr. Koch went through a range of issues. Clearly couldn't determine from this email exactly what was going to happen today, and that's my objection.
Okay. Well, notwithstanding the email, and I haven't seen it yet, the order, which was entered on January 23rd, 2019, clearly states that a hearing will be held today at 9:00 a.m. before the special magistrate with no additional notification the intent to pose a fine to be given in the event the violation is not corrected. So, was a copy of this order sent to the respondent?
I did not personally send it, but yes, I believe it was sent. I think Mr. Koch or Ms. Meredith might know.
And was a copy sent to Craig Galley's registered agent? Do we know?
Yes.
Okay, and was one sent directly to Palm Beach Polo Inc.?
Yes.
And what about, and he's not on here, but what about Mr. Dom? Was a copy provided him? Mr. Dom, is it your testimony, not your testimony, representation this morning that your client did not get notice of disorder and did not get a copy of it?
No, but it is my representation this morning that whether or not the order says something doesn't necessarily make it so within the Village of Wellington, and these things don't generally happen when they're supposed to happen. Circumstances change, dates change, notices change, the agenda changes, and sometimes we get notice, sometimes we don't get notice, and as a result, I rely on, or try to rely on, the final agenda that should be posted at 9 p.m. before the 9 a.m. meeting at least, so that we have an idea of what's going to be on the agenda for that meeting that morning, and that's what we have, nothing. So, notwithstanding the fact that they provide notice, and they do all of these things, but they also make changes as they go. They make changes on the fly, they change the agenda, they move stuff to consent, they take stuff off consent, they do all of these things, and we need to have an actual notice of exactly what's going to be heard this morning, notwithstanding prior notices, because the circumstances constantly change.
Okay. Well, I'm going to deny your motion. I think the order's clear. I think the presumption should be that the hearing's going to go forward unless you're told otherwise, not that it's not going forward unless you're told otherwise. So your motion is denied. Okay.
In addition to that, I wish to continue to make my record, and I wish to continue to make the argument that as we sit here today, Mr. Zangen, you are not a duly appointed special magistrate of the Village of Wellington. And I have exhibits 2, 3, 4, 5, 6, and 7, which I will submit into evidence in order to provide a record of the resolutions of the Village of Wellington that clearly show that you were not reappointed in 2016, and you were not reappointed in 2018 pursuant to the Wellington Code, that this hearing is a nullity. It has absolutely zero validity under the law, and notwithstanding the fact that you ruled last time on your own eligibility to be a special magistrate, which is mind-numbing, but you did, we're here still in the same position we were in the last time, the time before that in fact, you have not been appointed by the village council, which is a requirement under the code. Your term expired in June of 2016, and in fact, you have not been properly reappointed. You are not a special magistrate. You have no authority to act, and even if they choose to argue somewhere down the road that even if you're not, you have a de facto officer status, I'm telling you today, you are not a legally appointed special magistrate, and therefore you have no de facto status today.
Okay, this was argued, I believe, January, at the January hearing. Is that correct? What was the date of that hearing, the 21st? What was the date?
And is presently before the circuit court
January
of the
17th.
15th Judicial
So-
Circuit for them to make a determination, not for you to make a
Mr.
determination.
Dom understood. I'm going to consider this a motion for reconsideration, which I'm denying.
No, it's a motion to suggest to you that every time I come here, I am going to make the same argument until somebody tells me that you are a special magistrate, because I can read. And when I read the Wellington Code, it says that you are entitled to 4 two-year terms, and it means in each 2-year term expires and needs to be reappointed. And that, in fact, in 2016, you were not reappointed by the village council. In 2018, you were not reappointed by the village council. And that means that you are not a legally operating special magistrate with any authority to adjudicate any of these issues.
Okay? What else do we have?
Would you like me to respond, or it sounds like you've already
No,
ruled,
the
Mr. Zangen?
motion it has
I
been
don't
den-
have anything else, except, Mr. Dom, you gave me, I think, 2 copies. Is one of these
Yes,
for
one
the
for
special
the record,
magistrate?
please.
Okay, do we have anything of the substance concerning Mr. Dom, do we have anything concerning the plan that you were supposed to submit, the mowing of the property, the maintaining of the landscape?
The plan is being worked on. We will actually submit that plan shortly. I also have Mr. Straub here today to address any other issues with respect to the golf course. And if they're done presenting, then I'll call him. Otherwise, I'll wait till we're done.
I don't think that, you have anything else that you're presenting?
We don't have anything to add. We believe that we've satisfied all 3 of the factors,
Okay.
and it's appropriate to impose the fine that Deborah Mitchell spoke about.
When you say the plan will be submitted shortly, what's shortly? How do you define that? A week, a month?
Within a week.
Within, excuse me?
Within a week.
1 week?
Mhm.
Okay.
I just want to clarify that the plan was not something that we required. It was something that they suggested to us that they were going to submit as part of their efforts to correct, but that we haven't received it to date.
I understand.
Okay.
Okay. Does the village have anything else?
Well, since this is, I guess I want to clarify that statement. We've had several conversations regarding the fact that golf courses are different than commercial properties. Golf courses are landscaped differently than commercial properties. There are roughs, there are other areas, there are fairways, there are greens, the cuttings are different, the obstacles are different, all of that is different. And in my discussion with Mr. Basehart, he said, well, if you want to do something on the golf course that is not within the code, submit a plan, we'll go over it, and we'll see if it makes sense. And so it's under that guideline that we said that we would indeed submit a plan to show why the grass needs to be higher between the driving range and the cart path and the roadway. And I mean, it's just simple. Part of it is a natural barrier to prevent the balls from going out there. Part of it is a rough. If you have a practice area with a driving range and with a putting green and a chipping area, you should have an area with a rough. And it's a golf course. I mean, that's the bottom line here. And so if we can submit that plan and maybe have it approved, then all of this goes away, because it's not about, did you cut the grass, when you're talking about a golf course. And I've had this argument, I've made this argument abundantly clear many times. Of course, it always falls on deaf ears, but nevertheless, that's the argument. And so we'll submit something to the village and see what they say. But that's the idea and that's the plan, and we just haven't quite gotten there yet. We've been rather busy on other things, but we'll get there.
Okay. You said a magic word that perked my ears up. You said grass. When I heard the code enforcement officer testify, she said weeds. This hearing and the original hearing back in January. I know you're not the witness.
Correct.
But are there weeds on the property, or is it strictly grass?
There's over 300 acres of golf course property. Some are active, some are inactive. I'm fairly certain there may be a weed or two here or there. But just like in 300 acres of land, a palm frond may fall from a tree somewhere. Does that mean that the golf course is not in compliance? Do we have to go through this process because there's a palm frond or a weed when you're looking at the overall thing? The grass is now being cut pursuant to the new code to 6 inches. We've taken down trees. We've done everything we can do. And I know that my client is itching to tell you where we go from here. But it's impossible to maintain 300 plus acres to perfection constantly while Ms. Mitchell drives around daily looking for stuff to find and write us up about. So that's basically the problem, Mr. Zangen.
Okay.
Mr. Zangen, first of all, we're not here to re-argue the violation. We're here to assess the factors and determine what fine would be appropriate. And our position is that the landscaping is not being maintained in a healthy, neat, and orderly appearance, which includes, as you can see from the photos, overgrown grass, weeds, dead and bare areas, and dead fronds. The violation has not been corrected, and we believe that it's appropriate to impose a fine at this stage. Certainly, if the property owner submits a plan that allows for the grass to be longer, that might address one element of the issue, but it would not address the weeds or the dead and bare areas or the dead fronds, and it hasn't been submitted to date.
Okay. Again, this is just a fine certification, but if Mr. Straub wants to come up and address the,
Thank you.
this hearing. Yes, sir.
It's become to the point to where,
Mr. Straub, before you go, just state your full name for the record, and you need to sign in.
I'm gonna do anything wrong here. Did you sign in? I did. I didn't see it. Is that your name? Yeah.
I wouldn't want to do anything wrong either.
I'm not making light of procedures. I'm glad we have some procedures to abide by, but
Okay, if you want to keep doing right, your full name for the record, please.
Glenn F. Straub,
Okay.
11199 Polo Club Road. I think I have a
Now
couple,
you may proceed, sir.
3 different apartments over there on, or residencies. To have the chief executive officer over 700 properties that I run, to have to come to these type of meetings, I think it puts things in perspective to what we're really talking about. First of all, starting from the end of what was mentioned by having an attorney have to show up every time, have to go into court and spend the money. It's become, Wellington is not a business climate for golf courses anymore. Did a nice job in equestrian. I think I helped that out 26 years ago when everything was boarded up on the 2,200 acres that I bought. But likewise, I think it's with a little bit of help and some money and some time, we've given Wellington an industry of equestrian. But just as though PGA, I think, just lost the Masters golf tournament, I think they call it Honda Classic, I heard. I know for a fact Miami lost the Lipton tennis facility, moved it up to Hialeah or someplace. The Wellington's going to have to watch its relying only on equestrian, because I know what the prices are going to, and we kind of priced ourselves out of the market, and we know where we're going to be putting some money into other areas of the country where equestrians might end up going to. So what I'm happy to address is the fact that Wellington's, how many golf courses have lost in the area, and to have nitpicking things like this occur to where we have inspectors going up inside, onto the property, up inside of a 40-year-old or more comfort station to get out of the rain that can't be any bigger than probably 12 by 12, 20 by 20 maximum, no bigger than 3 or 4 of those chairs sitting up there, and take and write us up for a mural that was done, that was been done, and very, I think, very nicely. Nothing like Miami has their area of Miami that is strictly, I think, 50 restaurants and bars and everything else that's made up with graffiti all over the place. And that's the atmosphere and the look, and that is art. The same way inside of a comfort station, and the one wall is one way, one wall is the other way. You can't see it from any house, any way, shape, or form. And yet, that and I noticed on the pictures that she wrote up something about this week was the canopy that we use for people to go in when it's raining and give golf lessons. I've made a decision that we're just going to close everything down. It's going to take a couple months to replace employees and this and that into some of these other golf courses outside of Wellington. But I think we've gone from 4 golf courses since I come here. This nitpicking bullshit that you come up with, that picture isn't of anything close to, of where this is. You just have people that have to come up and justify their job. If you want to do that and get yourself into trouble, very easy, people. I write a order out and things just shut down. And let your community say what you're trying to do. I did it for soccer, and we went through 3 years of fines on soccer fields, $1,000 a week or whatever it may be. These things just keep adding up, and nuisance factors will take you to court, and the court system takes some time. But I'm going to address today, I've made that decision, so you don't have to worry about from here on out. There won't be any more fines. We're going to cut things with brush hogs, and if you know what a brush hog is, it's a crude form of cutting grass to keep it below 6 inches, and it costs us nothing, and I'll lay off 50 employees, and I'll go ahead and have a simplified form because I think we're the only people that have the remaining acreage in Wellington to develop. But thank goodness we were debt-free when we came. We're still debt-free, and we're not going to put up with this. This is total harassment. Every week something's coming up. We go out, trees. We have 3,000 trees on, I think it's over 500 acres of golf courses. We have 3,000 trees, and somebody came up this morning and said, well, you didn't cut the right tree. And we went down, had our employees cut the trees, had to have them show us which trees to cut. We went and removed the debris, and they're still coming up with, oh, well, I guess there would be 3,000 trees. We're going to have hundreds of trees dying all the time, and windstorms and limbs and everything else. It's silly. It's total silly. When golf courses have to have roughs. You can't have everything fairways. If not, you have what our golf courses are up north in Martin County and St. Lucie County. They're as clean as this tabletop is because the people are 80 years old that play on them. And so you never have a rough. These courses are the best there are here in Florida. The Cypress course. They've already shut down Dunes course last year because of the harassment. Now we're getting into the Cypress course. Now, not only that, because you don't have anything you can do on those courses because we've already met the code requirements that you passed a new code. But now we're going to go ahead and go after the driving range, the practice areas. Those 20-some acres are used so people can get some experience in doing what golf is before they go out on a golf course and waste their money driving around 175 acres per golf course and losing balls and everything else because they didn't have a chance to practice and warm themselves up correctly. So thanks for making my decisions for me. This had nothing to do here. I'm just rehearsing what it's going to be when my members, whatever members we have left, because they're equestrian. We're going to be a house. We're going to be like Olympia, no golf courses, no soccer fields, nothing underneath the driving range. That's the other, or not the driving range, underneath the power lines. Power line, I had 8-foot high trees, 10-foot high trees. I go in and cut them all down. Not ever look for a thank you, but now they write us up on that. It's for the driving range where we put 2 perfect soccer fields in. It's taken me over a year to get that done and all the fines. So I appreciate you giving me a few more minutes, but we're going to simplify all this stuff and just you won't see it being open next season, and we'll move this thing down to where I'm not going to put up with it, and I'm not going to have our chief executive officers whenever I get replaced, which will probably be the 2 kids. And so we'll go ahead and just announce it. Blessed are you guys. You think that when government starts controlling, which these are properties that we zoned, bought, and did everything else for golf courses. Now you're telling us how we're going to save the safety of the people running up and down you saw the pictures of there it is right there, of the golf cart path, which is within 150 feet of a guy hitting a ball 165 miles an hour right next to him. And you want to go ahead and have this to stop the balls from going out and hitting baby carriages and everything else. Safety, the fact that you need to practice putting, chipping, sand traps. You need to work in rough areas. Out of that total area, it's within 1 inch of the ground. 100, let me see, what is there? 23 acres in that driving range, just that part of the driving range. And we have a strip that's not even 50 feet wide, that's on a hill, some of it's on a hillside, that's 45-degree angle.
Mr. Zangen, I appreciate that Mr. Straub wants to be heard, but he's gone far afield of the factors that need to be considered for purposes of this hearing and asking.
That's exactly what I was dealing with. It was a piece of property that you don't even know where you're at. You got some picture of a weeds sticking out, and I can answer his question. There's no weeds there. There's no weeds in that driving range. And you have to have the rough area where it's at to keep the balls from going out and hitting the people. Number two, to be able to chip out of, to hit out of, and drive, because not everybody's a good golfer that stays in the fairway. And so that area, that is, you've got some area that's, a picture right now you're showing, that where wet areas will come up with these things, and we spray them, and it takes about 2.5 weeks to get rid of that weed right there. But it's not there constantly. Obviously, it's right next to our driving range and right next to our clubhouse. This is not a mile down the road where the cypress course would be. This is right next to our clubhouse. We don't do that on purpose. You take a picture when the wet area comes and your sprinkler systems from the POA, not even us, waters our property and causes those type of weeds to grow for 2.5 weeks until we get a chance to get in and spray the thing. Nitpickers, nitpickers, nitpickers. You've just created a atmosphere of non-conducive golf courses in Wellington and soccer fields in Wellington.
Okay, understood,
Thank you.
Mrs. Straub. Thank you. Okay.
Okay, the only thing I'll add to that is you have the ability to assess a fine anywhere from $0 to $250. The fact that they're asking for the maximum when this is not a repeat violation on something that we are trying to work through, and we are cutting grass, we are taking out trees as fast as they can point out which one's next. And at this point, you get to assess a fine based on that and based on our ability to do what we can do to make this happen. So I would suggest that the fine doesn't need to be quite what they're asking for.
Understood.
May I respond briefly? First of all, Mr. Straub has just testified that they're shutting down the course, but Mr. Dom has represented that they're submitting a plan, so we're not sure which it is. And additionally, while this is not a repeat violation on this property, this is a recurring violation on several other of the polo golf courses,
Which
so
is
it's
not
not a new
relevant.
violation.
Not relevant.
Ms. Mitchell, can I ask you a question? If you can approach. You're still under oath. Between the hearing on January 17th, 2019, and today, has any of the golf course, now this is the Dune Golf Course we're talking about, is that correct?
Well, this is the driving range. It's separate from the Dunes Golf
Okay.
Course.
So we're talking about the driving
It's a
range.
different parcel.
I understand, okay. Any of that area been mowed?
There's been a portion of that area that you saw the pictures of that's right along Polo Club Road. It's on the inside, more towards the manicured part of the driving range, but it's just been like maybe a bush hog swiped through. There should be a picture in there that would show you. It still looks the same. This is current from yesterday, but there's, keep going, Feroz.
Yeah, let's not look at the good part. Let's go to the bad part.
Couple more, I think, from there.
Joke.
Right here. You see where it's brown right there next to the green? That's been cut right there. To the left is the Polo Club Road. And that's where most of the overgrown grass and the weeds, and you see
Really?
the dead palm fronds. And so that has been cut in the last couple of weeks, maybe?
All right. Okay, here's what we're gonna do. Case number NOH 19-129, I find respondent in violation of the order and certify a fine in the amount of $150 per day from, is it January, from February, let me see, February 22nd, 2019. Okay, and cost in the amount of, is it $485.33?
Yes, sir.
Okay.
And we protest the validity of any order.
Understood. That's been denied. Okay, thank you.
Have a good day.
Next case.
Okay, we have no further respondents. We move to the top of the agenda, item number 1 on page 4. This is NOH 18-5668. Helen Archer is the code officer.
Helen Archer, Code Officer
Ooh,
for
just
Wellington.
send me a draft.
Case 18-5668. Respondent's name is Frederick Francois Peck Soto Gomez de Abreu. Property address is 14082, 14084, 14086, 14088 Wellington Trace, Wellington, Florida. This case was established on a neighborhood improvement. The NOV-NOH was served by posted notice on March 11, 2019 at the property and at the Wellington Municipal Complex. Correction date was March 17, 2019. An inspection on March 18, 2019 found the following items remained beyond the time given in the notice of violation of Wellington Code sections 36-22B1, wood trim surrounding windows and door frames, wood trim surrounding windows and door frames are deteriorated, stained, discolored. Kitchen window is broken. 36-22B2, parking area, driveway, and sidewalk are stained and discolored. 36-23B1, trash cans and bins are not screened from view. 36-23B3, trash and debris surround property. LDR 7.3.12.b, hedges surrounding the parking area are missing. Photos were taken. There has been no contact with the owner. There's no list pendants or bankruptcy on the property. The Code Compliance Division recommends the respondent be found in violation of sections 36-22B1, 36-22B2, 36-23B1, 36-23B3, and LDR 7.3.12.b. It's recommended that the respondent be given until April 18, 2019 to correct the violations or be charged a fine not to exceed $25 per day per violation for each day the violation continues to exist. It's also recommended that the cost incurred by the Code Compliance Division in the amount of $271.52 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violations are not corrected, it's recommended that a fine certification hearing be held before the Special Magistrate on May 16, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to impose a fine be given.
Okay. Thank you. Case number NOH 18-5668. I'll make the following findings of fact. Find that the respondent or their agent was not present. Code compliance officer was present. Based on the photographs, notices, and other documents that were introduced into evidence, I find the respondent was in violation of sections 3622B1, wood trim around windows and door frames are stained and discolored. 7.3.12.b of LDR. Hedges around parking area are missing. And I think there's one more. And section 3623B1, trash cans and recycle bins are not screened. Section 3622B2, parking area are stained and sidewalks are stained and discolored. And section 3623B3, trash and debris surrounding the property. I think I got everything, right?
Yeah. you did.
Okay, good. I'm gonna enter a fine of $25 per day per violation, 5 years C&D, cost of $271.52. And in the event Code Compliance Division is not contacted as required and/or the violations are not corrected, fine certification hearing shall be held before the Special Magistrate on May 16, 2019, at 9 o'clock a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you, sir.
Okay, next case.
Okay, the next two cases are item number 2, NOH 18-5705. The code officer is Clement Golding.
sir.
Clement Golding, Code Compliance Officer at the Village of Wellington, case number 18-5705. Respondent name is IH4 Property Florida, LP, Invitation Homes. Property address 13837 Folkestone Circle, Wellington, Florida. This case was established based on a neighborhood improvement inspection. Intervening wage was served by certified mail. Return receipt received. Correction date was February 19, 2019. Inspection February 20th found the following item remained beyond the time given in the notice in violation of Wellington Code Section 36-23B1. Garbage cans are not screened from view. Photos were taken to represent the condition of the property at the time of various inspections. Follow-up inspection March 5th, 11th, and 14th found the violation still exists. Based on search conducted by staff found that the respondent does not have pending bankruptcy action, nor is your list pendants filed against this property. I had numerous contact with Representative Mary on several occasions, advising her that the garbage cans were not removed. She stated that they was notifying the a 7-day notice, however their process work to have it remedied, and to date nothing has changed. It's recommended that the respondent be given until April 1, 2019 to correct the violation, or be charged a fine not to exceed $50 per day for each day the violation continues to exist. It's also recommended that costs incurred by the Code Compliance Division in the amount of $324.82 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and/or the violation is not corrected, it's recommended that the fine certification hearing be held before the Special Magistrate on April 18th, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to impose a fine be given.
Is there a picture of the mailbox that we're talking about?
No, it's just the garbage cans.
Oh, has that been, the mailbox been resolved?
Yes, sir. All the other should.
Okay. Case number NOH 185705. Make the following findings of fact. Find the respondent was not present, code compliance officer was present. Based on the testimony of code compliance officer, together with the photographs, notices, and other evidence presented at the hearing, I find that the respondent is a violation of section 3623B1, garbage cans not screened from view. They will have, I'm going to assess a fine of $25 per day after April 1st, 2019. Cost of $324.82, 5-year C&D. In any event, Code Compliance Division is not contacts required and/or the violations are not corrected, a fine certification hearing shall be held before the Special Magistrate on April 18th, 2019 at 9 o'clock a.m. The Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you, sir.
Next case.
Clem's next case is NOH 19-1537.
Clement Golding, Code Compliance Officer at the Village of Wellington, case number NOH 19-1537. Respondent names, Invitation, IH4 Property, Florida, Invitation Homes. The property address 1383 Folkestone Circle, Wellington, Florida. This case was established based on a neighborhood improvement inspection. Intervening wage was served by certified mail, return receipt received. Correction date was February 19, 2019. An inspection on February 20th, 2019 found the following item remain beyond the time given in the notice in violation of Wellington Code Section 62-9B2, inoperative, unregistered vehicles stored on the driveway. Photos were taken to represent the condition of the property at the time of the various inspections. Follow-up inspection on March 5th, 11, and 14 found the violations still exist. Basic search conducted by staff found that the respondent does not have pending bankruptcy action, nor is your list pendants filed against this property. And we have had numerous contact with Mary, updating her on the ongoing violation, and to see if she could speak with the occupants to get them to address and correct the problem. And today it is still existing. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 62-B2. It's recommended that the respondent be given until April 1, 2019 to correct the violation, or be charged a fine not to exceed $100 per day for each day the violation continues to exist. It's also recommended that costs incurred by the Code Compliance Division in the amount of $264.21 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is also requested. In the event the Code Compliance Division is not contacted as required and the violation is not corrected, it's recommended that the fine certification hearing be held before the Special Magistrate on April 18, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Boulevard, Wellington, Florida. It's also recommended that no additional notification of the intent to impose a fine be given.
Is that vehicle there every day, or?
It has not moved, sir.
And
And it's also blocking the sidewalk. This time I'm asking for $100 per day fine. The sidewalk is not accessible. It's across the sidewalk.
can we run through the photos again? Because you have parking on the landscape, but, okay, because it's parking over the, which violation, which code section is that,
For the sidewalk?
the sidewalk? Is that point, B1?
No, the sidewalk, you didn't cite for the sidewalk, right, Clint?
No.
Right, because the sidewalk is it's a
So-
parking ticket offense, but that's not getting their attention.
And he has no tag on there either.
Okay. So you have, you cite two sections, B1 and B2. One is unregistered vehicle, and one is parked on the landscape.
The landscape was corrected.
That's what I wanted to know. Okay. Thank you. So the green van is the only one that's unregistered? Is it one vehicle, or two?
There's
There's another vehicle behind it.
there's one behind the green van, but I can't tell because we can't go on the property.
How were you able to
They
tell?
have it backed into the garage.
Backed up.
Yeah,
backed
I
up
see that.
against the
How were you
house.
able to tell the green van was unregistered or no license?
There's no registration tag. You see,
Yeah, but how were you able to do it without going on the property?
you can see from the street.
Well, it's
From the
a
sidewalk.
corner house, isn't it, Clem?
It's a corner lot.
Okay,
So he was on the sidewalk.
See,
on
there
the
it is
other
right
side.
there. See, I take it from the sidewalk.
yeah, okay.
I
So we
zoom in.
can't
So
see
you just
the-
noticed nobody complained, this is not this is on your own, proactive. It wasn't a complaint,
No, I saw it. I saw it. Sir.
okay. Case number 19-1537, gonna make the following findings of fact. Respondent was not present, code compliance officer was present, based on the testimony of the code compliance officer, together with the notices, photographs, and other evidence presented. I find respondent in violation of section 62-9B2, an operative unregistered vehicle parked in the driveway. I'm going to assess a fine of $50 per day, and give him till April 1, 2019 to come into compliance, cost of $264. I think you said 24, is that right, or 21? 21, 264.21, 5-year C&D, and in the event Code Compliance Division is not contacted as required, and/or the violations are not corrected, a fine certification hearing shall be held before the Special Magistrate on April 18th, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Sir,
Thank you. Next case.
Next case is item number 3, NOH 19-307. Code Officer Lena Bott is out, so Feroz Khalil will take her case.
Feroz Khalil, Code Compliance Officer for the Village of Wellington, case number NOH 19307. Respondent's name, Justin Hausman. Property address, 786 Via Toscana, Wellington, Florida, 33414. This case was established based on a complaint. The NOV/NOH was served by certified mail, return receipt received. Correction date was February 27, 2019. An inspection on March 1st, 2019 found the following item remained beyond the time given in the notice in violation of Land Development Regulations Section 7.3.12.b, dead trees. Photos were taken that represent the condition of the property at the time of the various inspections. A follow-up inspection on March 18, 2019 found the violation still exists. Staff conducted a PACER search which found the respondent does not have pending bankruptcy actions. Research found there is a list pending file against this property. As of March 8, 2019, research found that the last action on the docket was a certificate of service. There has been no contact with the owner. The Code Compliance Division recommends the respondent be found in violation of Land Development Regulation Section 7.3.12.b. It is recommended that the cost incurred by the Code Compliance Division in the amount of $212.26 be assessed in order to be paid within 30 days of the date of this meeting. It is also recommended that a special magistrate issue an order for the village to abate the 2 above-mentioned dead trees at this property which are creating a danger to the public safety. A cease and desist order for a period of 5 years is requested.
All right. Yeah, they should have some kind of flashing light on the top of them. Keep the aviation away from them. Okay, case number NOH 19307. Make the following findings of fact. Respondent was not present. Co-compliance officer was present. Based on the testimony of co-compliance officer together with the photographs, notices, and other evidence presented, I find respondent in violation of Wellington Land Development Section 7.3.12b with 2 dead trees on the property. I'm going to issue an order allowing the village to abate and remove the trees to avoid any potential damage to the public. And assess costs of $212.26 plus any cost of removing the trees, 5 years C&D.
Thank you.
We typically don't ask for abatements for trees, but in this case, considering the proximity, we figured it was pretty prudent.
I use
Ask
those
for it.
as a landmark. I always know, you know, you're on Wellington Trace, right?
Yes, sir. All right, next case is item number 4, NOH 19-908. Clem Golding is the code officer.
Clement Golding, Code Compliance Officer, Village of Wellington. Case number NOH 19-908. Respondent name is Progress Residential Borough 1 LLC. The property address is 1899 Tulip Lane, Wellington, Florida. This case was established based on a neighborhood improvement inspection. End of NOH was served by certified mail, return receipt received. Correction date was February 27th, 2019. An inspection on February 28th, 2019 found the following item remain beyond the time given in notice. In violation of Wellington Land Development Regulation Section 7.3.12.b, landscape not maintained in a neat and orderly condition, dead and bare areas in lawn, and weeds throughout the lawn and on swale. Photos were taken to represent the condition of the property time of various inspections. Follow-up inspection on March 12, 2019 found the violation still exists. PACER search conducted by staff found that respondent does not have pending bankruptcy action, nor is there a list pendants filed against this property. There has been no contact with the owner. The Code Compliance Division recommends the respondent be found in violation of Wellington Land Development Regulation Section 7.3.12.b. It's recommended that the respondent be given until April 18th, 2019 to correct the violation, or be charged a fine not to exceed $50 per day for each day the violation continues to exist. It's also recommended that costs incurred by the Code Compliance Division in the amount of $229.58 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and the violation is not corrected, it's recommended that the fine certification hearing be held before the Special Magistrate on May 16, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard. It's also recommended that no additional notification of the intent to impose a fine be given.
Okay. Is it being mowed and just weeds? Because it doesn't seem very high. I mean, is there activity going on, Lance?
I don't
No?
think it's being mowed consistently. I don't think so, sir. But you can see where some areas it's worse than others.
All right, case number NOH 9:08. I'll make the following findings of fact. I find the respondent was not present. Code compliance officer was present based on the testimony code compliance officer together with the photographs, notices, and other evidence presented. I find that the respondent is violation of Wellington Land Development Regulation, Section 7.3.12.b, landscape not maintained, dead and bare areas, weeds throughout, dead palm fronds. I'm going to give them until April. Let me see, calendar. I'm not going to wait till the 18th. I'm going to give them until April 8th to come into compliance. Thereafter, fine of $50 per day, cost of $229.58, 5-year C&D. And in the event code compliance is not contacted as required and/or the violation is not corrected, a fine certification hearing shall be held before the special magistrate on April 18th, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to pose a fine shall be given.
Thank you, sir.
Okay, thank you. Next case.
Next case is item number 5, NOH 19-1787. Natalie Stahl is the code officer.
Natalie Stahl, Code Officer for the Village of Wellington. Case number NOH 19-1787. Respondent Deutsche Bank National Trust. Property address is 10404 Trianon Place. This case was established based on a neighborhood improvement inspection. The NOV-NOH was served by certified mail return receipt received. Correction date was March 13th, 2019. An inspection on March 14th, 2019, found the following items remain beyond the time given in the notice in violation of Wellington Code Section 36-22B1, roof stained and/or discolored. Photos were taken that represent the condition of the property at the time of the various inspections. Staff conducted a PACER search, which found the respondent does not have pending bankruptcy action or a Liz pendants filed against this property. Staff contact. There was no contact from Deutsche Bank. The Code Compliance Division recommends the respondent be found in violation of Wellington Code Section 36-22B1. It is recommended that the respondent be given until April 24th, 2019 to correct the violation or be charged a fine not to exceed $50 per day for each day the violation continues to exist. It is also recommended that costs incurred by the Code Compliance Division in the amount of $194.95 be assessed in order to be paid within 30 days of the date of this meeting. A cease and desist order for a period of 5 years is requested. In the event the Code Compliance Division is not contacted as required and or the violation is not corrected, it is recommended that a fine certification hearing be held before the special magistrate on May 16, 2019 at 9 a.m. at the Wellington Municipal Complex, 12300 Forest Hill Boulevard, Wellington, Florida. It is also recommended that no additional notification of the intent to impose a fine be given.
Okay, did you say you want to give them until April 24th to come into compliance? Was that the date? Okay. Case number NOH 19-1787. I'm going to make the following findings of fact. Find the respondent was not present. Code compliance officer was present. Based on the testimony of code compliance officer together with the photographs, notices, and other evidence presented, I find respondent in violation of Section 3622B1, roof stained and discolored. They'll have until April 24th, 2019 to come into compliance. Thereafter, a fine of $50 per day, cost of $194.95, 5-year C&D. And in the event the Code Compliance Division is not contacted as required and/or the violation is not corrected, a fine certification hearing shall be held before the special magistrate on May 16, 2019 at 9:00 a.m. at the Wellington Municipal Complex, 12300 West Forest Hill Boulevard, Wellington, Florida. No additional notification of the intent to impose a fine shall be given. Okay, thank you. Next case.
Next case is item number 6, was NOH 19-1897. We had an 11th hour and 30-minute stip signed this morning by the owner. Wellington agrees to provide until midnight of May 16, 2019 to come into compliance of removing a severely hat-racked tree. Potential fine of $25 per day, And the fine certification will be on June 20th, 2019, if the owner fails to correct.
Okay.
I think that is the,
Stipulation is approved.
I think that's the quickest stipulation we've ever done.
Wow.
Okay, we move to the fine certification portion of the hearing. We go to item number 2 on page 5. Is NOH 18-2015. Helen Archer is the code officer.
Helen Archer, Code Officer
Magic.
for Wellington. Case number 18-2015. Respondent's name is Frederick Francois Pexoto Gomez de Abreu. Property address is 14082 Wellington Trace, Wellington, Florida. Hearing date was July 17, 2019. The respondent was ordered to correct the violation of Code Section 18-32, 105.4, expired permit for AC changeout on or before February 21st, 2019, or pay a fine not to exceed $25 per day. The order also scheduled a fine certification hearing on March 21st, 2019, if the Code Compliance Division was not contacted as required and or the violation was not corrected. Research on February 25th and March 18, 2019, found no change in the permit in violation of Wellington Code Section 18-32, 105.4. The Code Compliance Division recommends the respondent be found in violation of the order of Section 18-32, 105.4, that the respondent be assessed to fine the amount of $25 per day per violation, commencing on February 22nd, 2019, and cost in the amount of $468.17, which includes the costs assessed in the order, both continuing to accrue until the violation is corrected.
All right. Case number NOH 18-2015. I find respondent in violation of the order and certify a fine in the amount of $25 per day from February 22nd, 2019, plus cost of $468.17.
Thanks.
Thank you. Next case.
Next case, it'll be item number 3, NOH 18-3122. Clement Golding is the code officer.
Clement Golding, Code Compliance Officer at the Village of Wellington. Case number NOH 18-3122. Respondent name is IH5 Property, Florida, LP, Invitation Homes. Property address 13591 Brightstone Street, Wellington. The hearing date was January 17th, 2019. Respondent was ordered to correct the violation of Wellington Land Development Regulation Section 7.3.12.b on or before February 21, 2019, or pay a fine not to exceed $50 per day. The order also scheduled a fine certification hearing on March 21, 2019, if the Code Compliance Division was not contacted as required and the violation was not corrected. Inspection on February 25, 2019, found the landscape is not maintained and need an orderly condition. Was partially corrected. There was weeds throughout the swale in violation of Wellington Land Development Regulation Section 7.3.12.b, which is in violation of the order. Force retained to represent the condition of the property at the time of the various inspections. Follow-up inspection on March 18, 2019, found the violation again was still partially corrected. The sod was not replaced in some section of the swale. Based on search conducted by staff found that the respondent does not have pending bankruptcy action, nor jail pendants filed against this property. I have numerous contact with Representative Mary and Doris. I've met the landscaper at the property once. I've also met with one of the agents, Representative Doris, at the property as well. And what you see, what they've done is replace some of the sod. They did some section and didn't do the other section of it. And the last conversation I had with her 2 days ago was that the contractor will be coming out to replace the remaining section and the swale where the arrow is indicating to the left. The Code Compliance Division recommends the respondent be found in violation of the order dated January 17, 2019 of Wellington Land Development Regulation Section 7.3.12.b. That the respondent be assessed a fine in the amount of $50 per day commencing on February 22nd, 2019, and costing the amount of $600.54, which includes costs assessed in the order, both continue to accrue until the violation is corrected.
Okay. So they're resodding part of it. I mean, it seems like everybody has weeds If they mowed the lawn, you wouldn't even notice the weeds, right? Have been mowing?
Well, the pictures, I don't know when we took those pictures, this is what it is at that time during the inspection.
At any time that you've been inspecting the property, has there been any activity mowing?
No, sir. No. Whenever I inspect that, we take pictures. So what the pictures represent is actually what occurred during that time.
All right. And the swale is all weeds?
Yes, sir.
Your testimony?
I met them twice. As I said, last week I met with one of their representatives, and they were not happy that the landscaper did not replace it, so they're coming out to do it.
All right. Okay, case number NOH 183122. I find respondent in violation of the order and certify a fine in the amount of, since they're partially, $25 per day as of February 22nd, 2019, cost of $654.
Thank you, sir.
Okay, next case.
Final case is item number 4, NOH 19-98. John Jarvis is the code officer.
John Jarvis, Code Officer with Wellington, case number NOH 19-98. Respondent's name is Roshni Gopi. Property address is 975 Lantern Tree Lane, Wellington. Hearing date was January 17th, 2019. The respondent was ordered to correct the violations of Code Sections 3622B1 and 3622B2 on or before February 21st, 2019, or pay a fine not to exceed $25 per day per violation. The order also scheduled a fine certification hearing on March 21st, 2019, if the Code Compliance Division was not contacted as required and or the violations were not corrected. An inspection on February 25th, 2019 found the wood trim in the rear of the property remained deteriorated. The rear door was still stained and the screen enclosure remained torn, in violation of Wellington Code Section 3622B1. The driveways and sidewalks had been cleaned, thus correcting the violation of Wellington Code Section 3622B2, and that violation has been dismissed from the case. Photos were taken that represent the condition of the property at the time of the various inspections. Follow-up inspection on March 18th found the violation of Code Section 3622B1 still exists. A PACER search found the respondent does not have pending bankruptcy action. Research found there is a lis pendens file against this property, with the last item on the docket being plaintiff's affidavit of default and motion to enforce stipulation and settlement agreement dated September 26, 2018. Staffs had no contact with the owner. The Code Compliance Division recommends that the respondent be found in violation of the order of Wellington Code Section 3622B1 and that the respondent be assessed a fine in the amount of $25 per day, commencing on February 22nd, and costs in the amount of $400.26, which includes costs assessed in the order, both continuing to accrue until the violation is corrected.
See, now there's a property with weeds in its landscape. Okay, case number NOH 1998. I find respondent in violation of the order and certify a fine in the amount of $25 per day commencing February 22nd, 2019, cost of $426.
Thank you.
Okay. I
And
believe
that
that's it.
concludes- Yep, that concludes the agenda,
Okay.
sir.
This meeting is adjourned.